Good morning and welcome to Workplace Television. I'm Jennifer Lupo. Today I am pleased to interview Noah Hanft. Noah is the president of CPR, an alternative dispute resolution provider. Welcome, Noah.
Thank you. I'm delighted to be here.
So, let's start with your credentials and training, academics, etc.
So I went to American University as an undergraduate at School of Government and Public Administration. And right after that, I went right into law school because from the time I was 7 years old, I always wanted to be a lawyer, probably inspired by Abraham Lincoln, who I continue to worship even through today. And I went to Brooklyn Law School and really enjoyed it. And from there, I was interested in trial work, so and at the same time interested in public service work. So I joined the Legal Aid Society, where I was a criminal defense lawyer for 5 years. That's how I began my career. And interestingly, a lot of people ask, well, when did you first become interested in alternative dispute resolution? And it actually started then because I came to realize very quickly that your clients needed you to negotiate good resolutions. It was all about plea bargaining, and it continues to be the case today. So finding the right solution for cases, whether they be criminal, civil, became something that I realized early on was incredibly important.
That's excellent. So Noah, were you the first or the second or the third generation in your family to attend college?
On my mom's side, I was the first generation. My dad attended college after he was in the service under the GI plan.
Fantastic. That's fantastic. So you just gave us a little bit of the beginnings of your career, how you started in the Legal Aid Society. Now let's fast forward and let's talk about how you ended up becoming the president of CPR. What was the training that brought you to here, other than the plea bargain?
Right. So I won't say what year, but way back when, I was working at a law firm in the intellectual property field and decided to explore the notion of being an in-house lawyer with a company. And my thinking there was to actually be involved in decision-making and getting involved in issues before they became, or entered litigation. So I worked for MasterCard. When I joined back in the mid-1980s, I did not expect to actually be there for over 27 years. But I really grew up in the company and did a lot of different things, ultimately becoming general counsel in 2000. But during that time, I was responsible for most, if not all, the company's litigation. And I came to realize that litigation can be a very frustrating, unproductive process. Not only because sometimes you lose, but oftentimes, even when you win, you lose. And I mean that because of the distraction to the business, the impact on relationships that litigation brings. So I really became intrigued by alternative dispute resolution, mediation and arbitration as well. But in particular, I think mediation gives you the opportunity to really find resolutions that you couldn't otherwise obtain in court. So I really became an advocate of mediation. I got to work with some of the great mediators on some very, very large antitrust and intellectual property cases, as well as some employment cases as well. In fact, I think there's virtually no kind of dispute that doesn't lend itself to mediation.
Well, you know that I agree.
I do.
Now, for our audience, most don't understand what dispute resolution is. So could you give us a quick primer on the different types of dispute resolution? And second, at what point in time folks should consider different types of dispute resolution?
So I think every civilized society comes to realize that dispute resolution is critically important. And there's the rule of law that obviously civilizations need to have boundaries and rules for its citizens. Whether in the business world or on an individual basis, the ability to resolve conflict in a thoughtful, productive way is incredibly important. And dispute resolution can be addressed in different ways. There's obviously just simple negotiation. You and I have a dispute. We sit down and we work it out. A very common way of dealing with conflict, whether it be personal, business, or otherwise. But oftentimes, it's not that easy. And that's where the presence of a third party, a mediator, can really help in the process in terms of bringing the parties together and finding ways that are in the interest of both parties to resolve a conflict. Oftentimes, if you are in litigation, you either win or lose. It's a very binary kind of process. But in mediation, you focus on the interests of the parties and what they really care about, and in that manner, the mediator can help the parties come up with resolutions that really address concerns and interests of all the parties.
And do you want to speak a bit about arbitration?
Yeah, I think arbitration is incredibly important and useful tool for everyone, companies and individuals, to really think about and use as an alternative and as a really interesting alternative to litigation. The reason I say that is arbitration is a very creative, flexible process, very adaptable, so that parties can actually define the terms of the arbitration as opposed, again, to a court where there's much more rigidity in the process. Arbitration is less expensive, it's more informal, and one of the beauties of arbitration is the parties actually get to pick the decider. That doesn't happen in court. You may end up with the judge you like, oftentimes you don't, but with an arbitrator you can decide whether for your case you want someone or a panel with expertise in a particular area, which makes arbitration a very advantageous way to address disputes.
Thank you. So, you know, I'm an attorney and an arbitrator and mediator myself. So, there are service providers. CPR is one, and there are two others. What distinguishes CPR from the two other major players?
So I think, and I have a great deal of respect for all the service providers in the ADR community. I mean, I certainly should say all of the major service. I mean, it's AAA, JAMS, great organizations. They do really good work. In fact, CPR partners with them in a number of areas, including diversity, which is an incredibly important area in the ADR space, something that I'm passionate about and have been for some time. Encouraging the use of alternative dispute resolution. So we work together with the other organizations. But what makes CPR unique is that it's an organization that's both a service provider and a think tank. And we were formed by general counsels over 40 years ago, frustrated with litigation, seeking alternatives to traditional litigation. And so some of the work that CPR does is really to just drive the adoption of alternative dispute resolution around the world. For example, CPR went into Brazil about 6 years ago, where there were a lot of concerns about an incredibly litigious environment where it would take over 10 years for a case to get to court, and a very, very adversarial kind of environment, and with no history of mediation. So we ended up actually running mediation programs, training a whole class of mediators, and encouraging the Brazilian legal community to adopt alternative dispute resolution with great success. That's part of the think tank work that CPR does, and the other organizations are essentially service providers. And the other thing I'll add is that because of our focus on the users, I mean, many of our members, or most of our members for sure, are users. They're law firms and corporations. And they play a role in our committees that actually draft the rules that apply to CPR cases. In that way, they tend to be very pragmatic, very creative and innovative, and the members then get to actually utilize the fruits of their collective innovation. So it's kind of a cool iterative process that I think is very, very beneficial. And one other example I'll mention, you know, there's a lot of back and forth about the selection process for arbitrators.
Absolutely.
A lot of people like the notion of each party selecting an arbitrator. but some feel that leads to arbitrators maybe advocating for one party or another, or at least creating a concern about that. So CPR came up with a screen selection process where the parties can actually designate an arbitrator, but the arbitrator doesn't know which party put their name forward, hence the screen. And in that way, and arbitrators say it just takes that whole issue off the table because there's no ex parte communication and we don't know which party actually put our name forward. So we truly can be neutral and independent without anyone kind of questioning, whether there's any kind of like favoritism. So those are the kinds of things that CPR does actually in terms of innovating based on user input and concern.
That's really interesting, the screening tool. So on that issue of diversity, which is tremendous, I need to congratulate you and CPR for the recent panel, and I want to get the name right. So it was called The Diversity Dilemma, ADR in the Aftermath of JayZ. So can you speak a little bit about what that means?
Sure. I think, the JayZ case created a lot of consternation in the ADR community, and I think there's a prevailing view that that there wasn't necessarily a whole lot of merit to JayZ's legal position. But my kind of reaction to that is, so what? What it did was shine a light on a really important and challenging issue that's been kind of vexing the ADR community for decades, and that is the just incredible lack of diversity in the ADR field. It's something that I noticed when I joined CPR. I think there are a lot of reasons for it. When I was at MasterCard, I oversaw all of our diversity initiatives, and we were able to move the needle sufficiently, and we had a very robust supply of diversity program. But that didn't encompass neutrals because they're hired by law firms, so it kind of slipped under the diversity radar screen, if you will. And I think that's the case with a lot of companies. So, and I'll talk about what CPR is doing in this space in a minute, but I think what the JayZ case did was actually brought to light some of these concerns and led to a number of discussions about not only what we're doing, which I'll talk about, but what more we can do. And I think that's, it's incumbent upon all of us in the ADR community, black, white, young, old, gay, straight, whatever, to ensure that our overall clients get the benefit of what inclusion and diversity bring. And so, long-winded way for kind of highlighting, I think, the importance of the program. And we ran a program with the National Bar Association. We had, I won't go through everyone who was on the panel, but I was fortunate to be included on the panel. And we really had the opportunity to talk about what's going on, what's causing the problem, and what more we can do to address it. Now, in the case of CPR, we looked at this and said, okay, we think like a four-pronged strategy is the way to continue to address the diversity challenge. And I look at it as starting number one with the pipeline and growing the pipeline. There are many incredibly talented, diverse neutrals, mediators, and arbitrators out there today, but the pipeline could be larger. And so we need to grow the pipeline. That's the first thing, and CPR is reaching out not only to the National Bar Association, through other organizations, really looking for qualified, highly qualified neutrals. So that's growing the pipeline. But then the second component of it is actually nurturing and mentoring the pipeline. And CPR has a program with FINRA and the LCLD. The LCLD has fellows, and we actually provide to those individuals a combination of a mentor, training, including FINRA training. And the idea is for them to take the training, then they can get on the FINRA panel, and that leads them to the CPR panel, which requires experience. Getting experience, as we all know in the industry, is the biggest challenge thing. So that there's, as I said, pipeline and then mentoring. Now the third component is, I would say, promoting the neutrals. So now what we've done is we have a brochure on our leading female neutrals, and we plan on doing the same thing for arbitrators and mediators of color. So that's the third prong, promotion. The fourth prong is the most important one. And that's one that I've been talking about since I joined CPR, and that's getting them selected. It's not about how many people, that are diverse that are on your panel, it's are they getting selected. So one of the things CPR did, just in the last year or so, was in our nomination form, when we provide the names of neutrals to companies, we actually have a diversity statement where we say that it's recognized that a diverse panel is an advantage. Diverse groups make better decisions, and so we really encourage the adoption, the selection of diverse neutrals when companies or law firms are making the decisions. And I'm really pleased that our selection rate is actually higher than the percentage of diverse neutrals on the CPR panel. It's over 31%.
That's excellent.
So we're going in the right direction. I in no way mean to imply that we've got it all figured out. There's lots more we can do, but we think that four-pronged strategy is a start, and it's the right way to go.
And indeed, just kudos to you to have recognized a problem and stepped in and worked with your constituents here within CPR to better the alternative dispute process for everyone. So, I have a question. Do you mentor anyone?
I do. Right now I have about 3 or 4 mentees. And then I have a number of informal mentees.
Of course.
So I spend a fair amount of time, mentoring. And it actually goes beyond the ADR field. I was at MasterCard for 27 years and have a lot of continuing relationships with folks. And my mentees come all ages, from all backgrounds, but I say that, but I probably get more out of the relationship than the mentees, because I learned so much from the mentees, and being, I don't want to say old, but on the older side, I get different perspectives and really different ways of looking at things. So it's a really really beneficial for me to have those relationships.
What's interesting is you actually speak to diversity for yourself there, right? When you say that you get more out of it than you think that than they actually do, which is a wonderful thing. I've been advocating for reverse mentorship, where folks who are newer in a field to mentor folks who have a more long-standing career for new innovation,
Right.
Which keeps everybody fresh, but also lets people see different perspectives and be able to work together across generations. So, you'll be leaving CPR soon for a new venture. Do you want to talk a little bit about that?
Sure, I'd be happy to. It's really, it's hard for me to say I'm leaving, because I have had 5 fabulous years with CPR. It's a phenomenal organization. I will continue to be active with CPR. I will be a member of CPR. I'm on the CPR panel of neutrals. But I had decided some time ago that I was going to reach a certain point where I really wanted to spend my time arbitrating and mediating and working with companies. I work with different corporations on settlement strategy and helping them figure out creative ways to work their way through business conflict. I think that I am, I don't want to toot my own horn, but I have been mediating and doing a little bit of arbitration for a number of years. And I think because I understand how companies think, and obviously I have the benefit of having the 5 years CPR, I think I know what most individuals and companies want to see in a mediation. I know what they don't want to see. They don't want to see a mediator who is just transmitting offers and demands back and forth.
Indeed.
They want a mediator who understands the case, who understands the interests of both sides, and can help them frame the issues and come up with meaningful, resolution to disputes. And I really do understand the frustration that some have with arbitration, and I know I know what they don't want to see in an arbitrator. So I think I can provide them with the kinds of opportunities to really avail themselves of the benefits of arbitration, an efficient, speedy process that's adaptable and that the parties can have control over, and that comes up with an award in a reasonable amount of time, and hopefully, not hopefully, but a fair and just process.
Fantastic. So have you set up a website or a telephone number or anything of that nature you want to share with our viewers?
Yes, I am in a partnership relationship with Richard Ziegler, who you may know. Richard was a partner at Jenner and Block until recently. Richard and I go back many, many years together. We're family friends. We both have previous general counsel experience. And so we set up Acumen ADR. It's www.acumenadr.com. I'll say that again. It's www.acumenadr. We have an office in the Flatiron area now, and we are really excited to be, working together on this venture.
That's fantastic. It's always nice to see folks innovating throughout their lives. So, I have one final question for you, and that is going back to, I'll tie it in a little bit to the Me Too movement and Time's Up. In employment discrimination cases and sexual harassment cases, there's been a backlash against arbitration. If you can give one piece of advice to both employers and employees with respect to the use of arbitration in workplace disputes, what would it be?
Yeah, that's a great question. I think there's a tremendous value for employees and employers to have and I'll go broader than arbitration, to have a robust workplace disputes program. Because if you have that in place, you have the opportunity for all workplace issues to be treated in a process that's very, very user-friendly and directed at resolution, as opposed to the potential for an ultimate fight. So by that I mean, if you have a workplace disputes program that I think is crafted correctly, you have open door policies, you potentially have an ombuds program, you have the opportunity for the employee who is dissatisfied with any aspect of the job. It could be salary, it could be the way a colleague is treating them, it could be the way their supervisor is treating them. There's a built-in process for dealing with those kinds of problems. If that process informally doesn't work, then I strongly believe there should be a mediation component. And if you have a good mediation program, very, very few cases. Statistics show that companies that have really strong workplace dispute programs, they almost never get beyond a mediation, because it's in the interest of the company and the employee to find a resolution. But having said that, if there is no resolution and the parties haven't been able to resolve it through negotiation and mediation and open door, etc., then arbitration provides an opportunity as we've talked about, in a less expensive, more informal way to find a resolution. Now, I personally believe that employees shouldn't be forced to arbitrate, so that if a company has a workplace disputes program and I join as an employee, I should have a period to, as we say, opt out of the program. But if I choose not to opt out and avail myself of the benefits of the program, then I think arbitration is a fair and effective way to find a resolution. And I know there are very different viewpoints on this, but there are some studies that show that employees end up doing better in the arbitration process than litigation. So again, I think people often look at arbitration versus litigation, and their view is going to depend on the outcome and how it comes out. So if you come out and you win, you like arbitration. If you lose, you don't like it. But in truth, I really believe that a good workplace disputes program and a good arbitration that's done fairly and effectively is a very positive thing for employees and employers as well.
Thank you, Noah. And thank you, viewers, for watching Workplace TV. the first stop toward finding solutions to challenges in the workplace for employers and employees. Be well and be successful.